Hi everyone, this is U.S. Immigration Attorney Sharifa Tharpe, and I am here live to take your U.S. immigration related questions. So if you have a question, go ahead and put your questions in the comments now, because I am here to answer your U.S. immigration related questions. Now let me formally introduce myself for those of you who don't know me. I am U.S. Immigration Attorney Sharifa Tharpe, and I help clients to get their green card and status in the United States. So if you've been through the immigration process, you're thinking about the process, then go ahead and put your nagging immigration questions in the comments right now, because that's exactly what I'm here to do. So I usually come with a topic to talk about, and I am going to give you an overview of the options that are available to you. If you are in the United States and you're being mistreated by a U.S. citizen or green card holder spouse, if you're under 25, a green card holder or U.S. citizen parent, or if you have a U.S. citizen son or daughter who's 21 and up and they're mistreating you, then you can apply for your own green card. So we're going to talk about what that process looks like, what does it entail. But keep in mind that even though I come with a topic that I think is important for you to understand and know about, I'm here primarily to answer your U.S. immigration related questions. So don't hesitate to put your questions in the comments as I am talking. Because I'm going to stop talking about my topic just to answer your questions. So feel comfortable to put your questions in the comments. There's no such thing as a dumb question here. So go ahead and put those questions in the comments. So does the mixed families qualify for the advanced tax credit? So that would be a question for your tax person. So go ahead and contact your tax person to ask that question. So go ahead and put your immigration related questions in the comments so that I may answer your questions. So let's talk about that. If you are here and you are, especially if you're undocumented, if you came into the United States with your status, with a visa, but you ended up overstaying, now you're out of status, even if you're in status right now. If you cross the border without your papers and you are here, you have a U.S. citizen or legal permanent resident spouse. If you're under 25, a U.S. citizen or resident parent, or you have a citizen son or daughter who is 21 and up and they're mistreating you, you can apply for your own green card. But let's talk about mistreatment. What does mistreatment mean exactly? So in the case that you're being mistreated, and it doesn't have to involve just physical abuse, it could involve emotional, financial, verbal, mental, as well as even financial, then you can apply for your own green card. So keep that in mind. It does not have to be physical abuse, doesn't have to involve the police, doesn't have to involve physical injuries for you to experience a form of abuse. So if you are going through something like this by a U.S. citizen or legal permanent resident spouse, parent, or even a citizen's son or daughter who's 21 and up, this could be a way for you to fix your status. And it's important for you to know this, because if you're stuck here, especially if you're stuck here. Hi there, Nikki Bless 39. It's so nice to see you here tonight. Especially if you're stuck here, undocumented, because of this abuse, because they're refusing to apply for you. Even if they're applying for you, you're in the middle of applying with them and they are mistreating you, there's a way for you to go ahead and apply on your own. Sexy Bless 5050, so nice to see you here. Thanks for coming on and tuning in. Thanks so much for saying hi. It's always nice to see you. So go ahead, feel comfortable to put your questions here, because I'm here to answer your U.S. immigration related questions. So now let's talk about, so we talked about the type of mistreatment that could qualify you for this. What does the application process look like? Hi there, KRC 2430s. Nice to see you. And Debria Rankin, thanks so much for sharing the live. I appreciate that. Claudia, it's nice to see you. Herb Woy Derms, it's thanks for sharing the live. I really appreciate that. Everybody here who's joining in, feel comfortable to put your questions in. It can be any immigration related questions. It does not have to be related to the topic I'm talking about, because I answer a broad range of immigration questions here. So go ahead and put your questions in the comments so that I may answer. So I have been talking about applying for permanent residence, the green card, based on mistreatment by a U.S. citizen or a legal permanent resident spouse. If you're under 25, a parent. And even if you have a citizen son or daughter and they're putting you through the ringer, they have been giving you trouble, then this could be a way. Now, mistreatment or extreme cruelty could involve verbal, emotional, not just physical. It can, of course, being physically harmed definitely qualifies you, but that does not have to be the case to qualify. Abuse comes in many different forms. And it can be verbal, it can be emotional, it can even be financial. So once you have determined that you qualify, and in order to qualify, this mistreatment, extreme cruelty, has to be by a U.S. citizen or green card holder spouse, parent, or citizen son or daughter. Now, once you've determined you qualify, it's time to apply. Then if I go adopt my grandkids, can I bring them, and how long I'm a citizen? So now, great question. There are ways to adopt your children. There are different ways to do this, and it's a more complex issue, and we'll have to delve further into into your circumstances. It's going to likely have to involve legal adoption, and your kids have to meet certain requirements. Like you have to adopt them before the age of 16. And then there are other requirements that they live with you, but it depends, because, and that's where you have, where it gets a little complex, because you do have to meet other requirements before actually filing the immigration papers. So first is the adoption and then filing the immigration papers. So it's very important. And then again, it also depends on the country. So go ahead, schedule a consultation, and then we can talk about a plan moving forward. It could be possible. How you're going to go about doing this, though, it depends on where the kids are, and which country they're in. I have a friend from Jamaica. She's here. She overstays. She have twin girls, 7 months, that are citizens. So Jennifer, thanks for asking this question. Now, having babies, unfortunately, having young children under the age of 21 is not going to automatically qualify your friend to get her green card. The children, U.S. citizen children, have to be 21 and up in order to qualify for permanent residence, and they have to actually apply, or they have to be mistreating the U.S. citizen parent in order for them to apply on their own. So thanks for that question. So I'm able to clarify that, because that is a common question that I get is, I have a child here, how can I go ahead and get the green card? And unfortunately, it's not so straightforward. The kids must be 21 and up. What's the wait time for a fiance visa, and what are the usual requirements? So right now the processing time is a little over a year, and in order to qualify, you have to show it. So the person petitioning for the fiance has to be a U.S. citizen, and in addition to that, they must show that they have seen their fiance physically in the most recent 2 years. from the date of applying. So that's important. If you're unable to do that, you have to show that you have experienced some exceptional hardships, or there's some cultural norm or cultural tradition that are cultural, religious, family tradition that prevents you from meeting your fiance in person. So there is a waiver if you can't see each other in person. Exceptional hardships, maybe there is a conflict in the country that's preventing you from seeing them, or you'll be persecuted in the country, and so that may qualify you to be able to get a waiver from that requirement. So if I open a business, can I sponsor her as an employee soon to open my company? So now that is a little more complex, and the reason being, if she overstayed, then your friend will have to fix her status. And in order to fix her status, she will have to apply for a waiver to go through the process, because with employment-based permanent residence, in order to stay in the United States and apply, you have to go from one status to the next without falling out of status. And obviously here with an overstay, that's not going to be the case. If you're out of status, you have to leave the country to finish the process in the home country. Now keep in mind, if that happens, she has to get a waiver before leaving the country. That's where it goes right back to family immigration. It's because in order to fix your status and get the waiver, your friend will have to have a U.S. citizen or legal permanent resident, spouse or parent who will experience extreme hardships if she doesn't get the green card. So this is where it gets a little complex, and you want to get legal advice before starting anything. Also keep in mind, with employment-based green cards, there is a labor certification process that you'll have to go through. So it's not usually just a matter of submitting the paperwork and waiting for an approval. With employment-based, it really is dependent on the qualifications of the immigrant, the needs of the employer, even the needs of the country, and that's where the labor certification comes in. They want to make sure that this position is not in any way taking away an opportunity from a U.S. worker. And so this labor certification, which is the more complex part of this process, is a requirement. So very important that you get legal advice to make sure that you are following the right path, but your friend would also still have to fix her status, and a part of that is getting a waiver. Now keep in mind, this is general information. It is not personal legal advice, and in order to do that, you'd have to schedule a consultation. How does a study visa work, USA and Guyana? So in order to get a student visa, there are different types of visas that may involve studying, but the most common one is the F1, and that's going to involve being accepted to a university. That university is going to issue what's called an I-20 document that will enable you to go through to the interview, show evidence that you've been accepted by a U.S. institution. And then also you have to show how you're going to pay for it. So for example, if you got a scholarship, if you got, or if you are being funded by a relative, or if you've gotten a loan through your country, these could be ways to show how you plan to pay for your education in the U.S. How much bank statement should you bring for your marriage interview? So I would say, to be on the safe side, it wouldn't hurt just to carry your bank statements from the very time that you had opened up your bank account. It depends on how long you have been together, but it wouldn't hurt to do that. So that would be my general answer. However, I don't know what your case is till 1981, and so I wouldn't be able to give you specific advice about how many bank statements you should be taking. But if I could and I am able to, I would print as many as possible to take in to show, because usually with the bank statements, they're going to be looking at one thing that the officers look at is the level of activity, because they know that two people can open up a bank account and just never use the bank account. And so they want to also see some meaningful activity going on to show that this bank account is being used and there really is commingling of financial resources. So very important that you print as many as you can to show a pattern that you do use your bank account together. Mrs. Toya, if my friend got divorced, can she apply for VAWA? Great question. Thanks so much for asking that. And yes, as long as she's been divorced for less than 2 years. So great question. And a lot of people don't know that. So if you have been divorced for less than 2 years, but you were being mistreated by your U.S. citizen or legal permanent resident spouse, then you can still apply for this. But once you get divorced, the clock is ticking. You need to make sure that you apply for the VAWA before the 2 years expire. Now, if you're going through this situation, give me a call, schedule a consultation, and we can get started on confirming you qualify and getting that application in. So Tug 1981, how do you dress for the interview? So I would say like a semi-formal, business casual, you know, a polo. So for women, for example, a nice blouse, a matching skirt. And then I would say no flip-flops, nothing, nothing inappropriate like that. So no flip-flops, nice closed-toe shoes or nice sandals, would work. So Mrs. Toya, call 561-405-4889. You can also share, if it's possible, share one of my videos where it has the number on it. You can also go to the link in my bio and it takes you to the website where you can copy and paste the website and send it to her. There's a contact form on the website as well as the number that you can call. Scheduling coordinators are available Monday through Friday, 9:30 a.m. to 11 p.m. to schedule. So plenty of time to call. If you have to work first and then come off work and call, a scheduling coordinator will be available. My fiance will complete his 5 years 2022 December. Can he apply for a citizen before? So the earliest you could apply is 4 years and 9 months. So you could apply a little early at the 4 years and 9 month mark. I have a case in Kingston. Immigration case is wait list long. So the time right now they're backlogged, and so you will find that there are long wait times for the interview. So even if you are qualified, you have submitted all your documents and now they're ready to schedule the interview, you may find that it's taking a while. So I've seen a wait time of 3 months to as long as a year to get on track because of COVID and all the anti-immigration policies that were in place that they're trying to reverse. So stay patient, make sure you keep up on your case, make sure you have everything submitted. So Mrs. Toya, I'm looking forward to hearing from your friend. My husband wants to sponsor me. I have status, but I didn't come to the USA legally. Do I need a lawyer? Momo Jonathan, I don't know your situation. So you do say that you didn't come to the US legally, but you have status. I don't know if this is DACA, but if it's DACA that you have or TPS, you should consult an attorney to make sure that you go on the right path, because if your husband is a U.S. citizen, even if they're a permanent resident and you came into the country without your papers, there is another process that you're going to have to pursue, and you want to make sure that you know exactly what to prepare for, what you need to do. It's through the waiver process. So consult an attorney such as myself. You can call 561-405-4889. These are the exact issues I deal with. So go ahead, schedule a consultation, and let's get started. If you miss the number, go to the link in my bio. It's going to take you to the website where you can get the contact information. Now, there is a scheduling coordinator who's available 24/7. An after hours receptionist. My phone line is open 24/7, so you can call and still leave your name and information. So my friend married for 2 years now. Her husband got arrested. can she still put in her papers for the green card? So that's, definitely have your friends call and schedule a consultation, because it's going to depend, where's the husband, what's the situation with the husband. If the husband was mistreating her, he's currently incarcerated, but he was mistreating her, that could be a way for her to apply on her own. If they're still married, how much jail time is he looking at? It may still be possible to apply for the green card. So call and schedule a consultation. Can't stress that enough, that she definitely needs to get legal advice. So my case still pending over 2 months now after responding to the RFE. So yes, you have to give it some time. And how long is the wait time? So KRC, I don't remember what your previous, okay. So right now, my cases are taking an average of 6 months, but it depends on the service center. What you can do is, if you go to uscis.gov and you go to case processing times, go to the service center nearest you and you'll see the range of time that citizenship applications are taking. And you could look at the N400. Hi there, I am United States and applied for asylum. Is it possible to apply for the EB5? So it is possible, but it depends on what your history is, because there may be, if you overstayed or you do have to fix your status at the same time, your process may be different, but it may very well be possible to go forward with the EB5. A child of a king, you are welcome. SD Black, thanks for the follow. A Wanda Butler, thanks for the follow. I appreciate that. So Sandeep 3825, there is no specific time that I can tell you. I don't know your case. I'm not the attorney on your case, so I don't know when you responded. I don't know what the situation is, what information they asked, so I wouldn't be able to give you a specific time. I do know in general that it is taking months for them to respond and get back to you on the RFE. Can my husband do my paperwork one at a time? So I'm not sure, Sweet Sash, I don't know what type of paperwork your spouse would be doing. Is this now marriage based, and are you talking about filing a petition and then filing for the work permit separately? So can you clarify for me? User Dig, you're welcome. So go ahead, keep putting your questions in the comments, because I'm here to answer your questions. And so far, I've gotten really good questions. For those of you, can you clarify for me your questions so that I can answer? My friend here on working visa, can he file for asylum? He's here not soon, 2 years. So in a case like this, I would want to do a consultation because there's always the opportunity to file for asylum, but you want to make sure that this asylum is definitely not frivolous, that it is something that he qualifies for. So it's important to evaluate, because every case is different, and so I would want to evaluate what the situation is in order to determine whether he qualifies for that. So marriage base, and yes, I-130. So it is always possible to do it one by one. However, Sweet Sash, it may not be the best. This is best strategy. It may not be the best approach, and it depends on your circumstances. Hi there, Dulce. It's nice to see you. Now, schedule a consultation, and let's talk about why you'd want to file one by one. Where are you? What is your status? What's the situation? What's your spouse's status? It's very important to know that before I would be able to answer any questions. The general answer here is yes, it's possible to do the papers one by one, but it may not be the best approach. So you want to get legal advice, Sweet Sash. Avi, okay, definitely. I'm looking forward to hearing from him. Go ahead, keep putting your questions in the comments. These are the exact questions that I answer. And keep in mind that I am here every day, with very few exceptions, of course. And when I'm here, I take any U.S. immigration related questions. So I submitted a green card application in January for my spouse, but have not heard anything. So if the first thing you should be getting is the I-130. That's the notice, the receipt notice to acknowledge that they've accepted your case. If you haven't received that, you should definitely check to make sure everything is okay, that they've received your case. If you received a receipt notice, some things are still taking very long, and yes, unfortunately, it depends on what process you're going through. For example, with the I-130 petition, it's taking even a year to get a decision on that. So things could go radio silent for that long, but check your case status. So Sweet Sash, I represent clients in all 50 states and the world. So I make it very easy to do consultations. For those of you who may not be close to me here in Florida, I'm in Boca Raton. I also meet my clients in Fort Lauderdale. I also do phone and video consultations. So it's very easy for those who are not close to me to be able to get legal advice. And as I represent you as an attorney, I'm very experienced in working with you, even from a distance. So go ahead, put your questions in the comments. And okay, so Estin, so yes, you got that. So right now, if you are not hearing anything, that's not exactly a strange thing. You're not alone. But what I would suggest you do is just check on your case. Make sure that they didn't send you anything that you didn't get, that there have been no errors in your case or anything like that. Just make sure everything is okay. And if everything is okay, then it's not unusual, unfortunately. If we're talking about just the I-130 petition, it could even take 9 months to a year to hear a decision. Joey, thanks for sharing the live. I'm a green card holder and in the process in filing for my two of who is with me. One is 22 and 20. So Geeta Singh, if they are with you and they're out of status, now if they're in status, you are totally allowed to apply for them. However, keep in mind that if at any time during the process they're going to fall out of status, you want to make sure that you understand the process totally and what is required. Because it's not necessarily as easy as a green card holder to file for your children and have them stay in the United States and get the green card. As a matter of fact, if they are out of status, they will not qualify to do adjustment of status. They will have to apply for what's called a waiver. It's a special type of forgiveness that allows them to leave the country in time for the interview and get the green card. But it's very important that you get legal advice to figure out what the best approach is. So how long is taking for marriage interview? So you could be looking at anywhere from 9 months to 18 months. Can you please tell how long it will take? So right now, for your 20, and with your 20-year-old, they might very well age out. Right now, it's taking, it could take about 2 years. For your 22-year-old, it's taking 5 to 6 years. So Geeta Singh, can't stress enough, get legal advice about what you need to do, because it may not be as easy, and so you want to make sure you are represented and you're prepared for this. What other options can be done to get his green card on working visa? So Avi, there's so many different options that this is where he would have to schedule a consultation. Just because I don't know his circumstances, I don't know, I would have to have specific targeted questions to be able to find where he could qualify otherwise. So very important, he schedule a consultation. My question is, if a person is being sponsored by a company, he has to sign the labor certificate. So usually this is all done by the employer. So it's usually the employer whose attorney does that aspect of it. Gemma, Thanks for following. Thanks for the advice and knowledge you're giving. So Mrs. Toya, you are welcome. Our Lil 2020, how long is taking for marriage interview? So it's taking about 9 months to 18 months. So they are in status. So Geeta Singh, so if they are in status, you want to make sure that they're able to maintain status for the entire time. Also, why it's very important to get legal advice. I don't know what status they hold. Are they students? And can they possibly maintain their legal status for the entire process? Because another thing you have to keep in mind is there is the misconception that you can come on your visitor's visa, you can apply while on your visitor's visa, and as long as you are in status while you're applying, even though you fall out of status later, a lot of people think that still qualifies them to apply for the green card while they're in the US, and that's not the case. If at any point in the process, even 2 weeks before the process is going to end, they fall out of status, they will not qualify for adjustment of status and they'll be denied. So very important that you understand. Okay, thanks. I will tell him to schedule one. Okay, great, Avi. I think that is the best option. So since I applied for a green card for my husband, do I need to apply for his work permit too? So great question. So usually this is a process with different forms. And Kalel, that is probably going to be the case here. So you have different forms where you have to sign. And so that in the case of the work permit, your husband is going to sign because he is the applicant. So there are different forms that have to be signed, and it depends, so you have to sign as a petitioner, the petitioner has to sign some forms, and then the applicant, the actual immigrant, has to sign certain forms. So hey, if I'm an international student, get married and apply for the green card, but just graduated and now in the 3 months period, do the students have to leave? So now it depends on who is applying for you, right? So Ralph, so funny, who is applying for you? Is it going to be a permanent resident? Is it a U.S. citizen? So that's where it's very important to get legal advice before you overstay. Make sure you get legal advice because it can definitely so a U.S. citizen. So Ralph, so funny. Now another thing is J1. You have to be wary of that. If your J1 visa has a 2-year foreign residency requirement, you're likely you'll have to qualify for a waiver in order to revert to get that 2-year foreign residency requirement waived. Now, if you are just a regular F1, you married your U.S. Citizen spouse, then it is still within your ability. It is possible. Keep in mind, this is not personal legal advice because I don't personally know your situation. However, generally speaking, you can adjust status if you are married to a U.S. citizen spouse, and that means staying here even if you fall out of status. Estin 1990, where can these forms be found? So if you go to uscis.gov, that's where you'll find the forms. Very important, Estin, get legal advice so you don't make any mistakes. Okay, so your F1, Ralph, so funny. So usually when you, once again, this is not personal legal advice. Generally speaking, F1 does not fall under one of those visas that prohibit you from adjusting status. I don't know what the rest of your situation is though, and that's where it's very important to get legal advice. Estin, you are welcome. So keep those questions coming while I'm here. Why not take advantage of a U.S. immigration attorney answering your questions right now? So can you tell me what 222G being stamped in your passport means? So I'm not sure what that means. You'll have to be more specific. What else was on that stamp? Ralph's so funny. You're welcome. So keep your questions coming because I am here to answer your questions. So put those questions in the comments so that I may answer those questions as they come in. I have been talking about a particular topic, but keep in mind that at any time, put your questions in the comments, even while I'm talking. I've been talking about applying for the green card based on mistreatment by a U.S. citizen or legal permanent resident spouse, if you're under 25, parent, or a U.S. citizen son or daughter who is 21 and up. If you are being mistreated verbally, emotionally, mentally, physically, but keep in mind physical abuse is not required to qualify for this. You can apply for the green card on your own. So, hi, I have a green card. It's valid till 2023. I did not travel due to the pandemic. The borders closed. Okay, so Basson, it depends on how long. Now, if you overstayed outside of the country for more than a year, there is a presumption that you've abandoned your permanent residence. Now, you have had situations where they are, they have been they have been a little forgiving about this. However, keep in mind that once you overstayed over a year, the more careful thing to do is to apply for what's called an immigrant visa, re-entry visa, returning resident immigrant visa. So it's called SB1 visa, and you're going to have to apply for it at the consulate. If you need further assistance, you can call. We can schedule a consultation to make sure you qualify. But usually you'll have to show that you didn't intend to stay outside of the United States, that you also maintained your ties in the U.S. during that time. If I want to legally live and work in the U.S., how do I start the process as a professional? So the first thing that you'll probably have to do if we're talking about an employment-based visa is to find an employer or an opportunity. So there are different things that you could do if you want to start your own business if you are the citizen of an E2 country. So E2 countries, if you go to uscis.gov and you go into the search bar and hit E2 countries, you'll see a list of those countries. But the examples in the Caribbean will be Jamaica, Grenada, Trinidad. In Central America, there's Mexico, Panama, Costa Rica. In South America, let's see. So keep those questions coming. I think I lost connection for a bit, but I am back. So keep those questions coming. So Joa154, thanks for sharing. Thanks for the follow. Michelle Porter, thanks for the follow. I appreciate it. Now keep those questions coming. I lost connection and I may have lost some of your questions. So go ahead and retype your questions. I am a naturalized citizen, but my mother isn't. My mother has been here for 20 plus years. Should I get a lawyer or do it myself? So Frankie, getting an immigration lawyer is not absolutely required. What I usually say though is important to make sure that you understand the process. And the best way to do that is to schedule a consultation. You know, with my consultations, I go through the details of your situation and I advise. And that usually gives clients the reassurance that they can either go through this process on their own or they need the help. So very important that you do that. You're never going to catch me saying you don't need an attorney. The reason being, an attorney knows what they're doing. They have the expertise in this area. And so you'll find that you can be good at what you're good at, while the attorney can be good at what they do. Take care of your situation. Take the stress off of your shoulders. Make it a smoother process for you. And because it's a smoother process, it can also turn out to be a shorter process. So that's my answer here. So can a lawyer take a lawyer to the day of the interview with my spouse? So I'm not sure what's going on there. No, I don't know what the situation is, and that's hard for me to answer. Now, if, for example, if maybe each spouse is represented by a different lawyer, maybe, but I'm not sure what the context is. So let's see. So Dulce, let's see, you lost the question. So you want to, okay, so Dulce, you're going to have to find an employer first, or and business opportunity. So there are so many, opportunities, employment based, but the first and the most important thing to do is to make sure that you apply for a job. So you have to find an employer who's willing to invest in you. So hello, after your biometrics appointment, how long it takes for the USCIS to send your interview date for the exam? So Mariam, it's nice to see you. Unfortunately, it's hard to tell, but what I can tell you to do is go to uscis.gov. And if you go to that website and put in the service center that, for example, the service center that will be processing your case, you will be able to see how long they're taking overall and get an idea of how long your case could possibly take. So that could be a good way to see. So if I overstayed my visa, will it affect my spouse file for me? So Zahari, yes, it could. It depends. Now, is your spouse a U.S. citizen? If your spouse is a U.S. citizen, and you overstayed your visa, you could very well qualify for adjustment of status. That means to apply for the green card while you're in the United States. However, if your spouse is a green card holder, then you may be looking at a more complex process, but it depends on the circumstances. And that's where it's very important for you to get legal advice before you file anything, to make sure that you don't make any mistakes, that you know what you qualify for, you know what you're in for, you know how to approach it, and you walk out with me as your attorney should you need that as well. Okay, so Zahari, he is a citizen. So if he's a citizen, then spouses of U.S. citizens, even if they overstayed, could apply for adjustment of status. Assuming everything else falls into the place the way that it should. Hi, Jay Hind, it's nice to see you. So good night. After Prima should be biometrics appointments to get the work permit. So yes, that will likely follow. So if you haven't done your biometrics yet, and you could very well get your prima facie before you get your biometrics. So if you haven't had your biometrics, then that is going to be the next step. Zahari, you're welcome. So thanks everyone for your questions. I am going to head out for the night, but I will be back tomorrow. So go ahead, follow me if you're not already following me, because I am here every day. I show up every day with few exceptions, of course. Now, when I'm here, once you follow me, you get notice that I'm live and you can hop on and ask your questions. I'm going to finish up here. Hi there, Tubi Chukwu. It's nice to see you. Claudia, you're welcome. Thanks so much for saying that. Now, today I brought the topic of applying for the green card on your own, applying for permanent residence on your own if you're being mistreated by certain qualifying relatives. Estin, you're welcome. Now, I just want to finish up by saying that even if you came into the country without your papers, even if you came into the country with you and you overstayed, then there is still you can apply for this, and you can stay in the US and apply for it and get a work permit while you wait. So it does offer a solution to fix your status if you qualify, meaning if you're being mistreated by a U.S. citizen or green card holder, spouse, or parent. So can I take a lawyer at the day of the interview? So Frank Jet, yes. Yes, absolutely you can. So Jay Hind, let's see. Please tell me if someone wants to file 10-year green card but no partner. So you now, very important, Jay Hind, very important that you get legal advice. The reason being, if you can't do joint if you don't have the partner. If the partner is no longer there, you have to qualify for a waiver. So that waiver is going to be based on divorce. It's going to be based on extreme cruelty or mistreatment or your extreme hardship. And it's very important that you make sure that you get legal advice and get assistance, because it's a little more complex and it does take preparation to get this right. So get the evidence right, make sure to submit the request for this waiver. Very important that you get this legal advice. So how long takes the waiver to get the 10-year green card? So the waiver is a part of the process, and right now you're looking at an average time of 18 months. You could also look at the timeline based on the service center. So all right. So thanks everyone for scheduling. I mean for your questions. And I will be back tomorrow. So go ahead and put your questions in the comments tomorrow, and I will go ahead and answer. Now, Devilicious, I noticed that you had a question about the 222G across your passport. And it appears that there is I don't know if this happened and you were turned around. Usually when this happens, you're turned around, where your visa is canceled due to an immigration violation. So in this case, if you would like to talk about what happened, you can call, schedule a consultation, and then I can go more in depth with you. But usually when you have the 222G written across your visa, it's going to be something related to an immigration violation. All right, so thanks everyone. Thanks for your questions. And Devilicious, you're welcome. All right, so have a good night everyone. Now, if you would like to learn more about me, go to the link in my bio. That's the best way to get in touch with me. You'll see the phone number, you'll see a contact form. The phone lines are open 24/7. So there's an after hours receptionist right now, and Monday to Friday, there's a scheduling coordinator who's available 9:30 a.m. to 11 p.m. So very important that you go ahead and schedule a consultation, because all the information I gave you today was general information, not personal legal advice. You want to make sure you get personal legal advice before you start any process. It's the best thing you could do. Have a good night, everyone. Bye-bye.